I'm Justin Silverman of the New England First Amendment Coalition. Welcome to this month's 30-minute skills class, Hipaa and Public Records. I want to remind everyone that all of our 30-minute skills courses are available to view at nfac.org. And if you've been joining us every month, or if you're new to the program, if you find these classes valuable and helpful to your work in any way, please consider becoming a sustaining member. Help support these programs. Make sure they continue in the future. Go to nfac.org/join and become a sustaining member today. We have a great program, so let's get right to it. Our instructor today is Adam Marshall of the Reporters Committee for Freedom of the Press. Adam, all yours.
Thanks so much, Justin. And thanks to everyone for being here today. I have a presentation that I hope you can follow along with. So as was said, I'm Adam Marshall. I'm a senior staff attorney at the Reporters Committee, and I'm super excited to talk to you all today about Hipaa. And the first thing to know about Hipaa is how it's spelled. It's not H-I-P-P-A, as in, hippopotamus. It's H-I-P-A-A, which stands for the Health Insurance Portability and Accountability Act. It's a law that was passed by Congress in 1996. Before that, there was very little in terms of federal laws establishing privacy for health information. And so in 1996, Congress thought that they should probably do something about that. And they did. One of the interesting things about Hipaa, though, is that it actually did not set forth the privacy standards that we know today. Congress gave itself some time to try to figure those out. But it said, well, if we can't figure it out, then the Department of Health and Human Services will have to issue some rules about it. Perhaps to the surprise of no one, Congress couldn't figure it out, so they kicked the can over to HHS, which then established rules that went into effect only in the early 2000s. So Hipaa is really not that old. But one of the primary parts of the regulations that we're going to talk about today, and the one that everyone really thinks about when they think of Hipaa, is called the privacy rule. And the goal of the privacy rule is to, quote, assure that individuals' health information is properly protected while allowing the flow of health information needed to provide and promote high quality healthcare and to protect the public's health and well-being, end quote. That sounds very nice and kind of lofty ideals, but the privacy rule is frequently misunderstood. Part of the reason for that is that it is very, very dense. It is very long. If you combine the text of it together, it's about 105 or so pages, and it is, even for lawyers, I think it's quite a task to go through. So you have Hipaa and the privacy rule, which are very complicated. And then you have COVID-19 come along. And all of a sudden, these two things are smushed together. And you have a lot of confusion, questions about what is the interaction between these two kind of monumental features of American life. And so that's what we're going to try to disentangle a little bit right now, specifically when it comes to public records. I know a lot of people have questions about this because there are a lot of questions about what are governments doing when it comes to COVID-19. Early on, there were questions about what kind of data does the government have when it comes to COVID? Where are the cases? Are there cases in nursing facilities or long-term healthcare facilities? Are there disparities in COVID cases between members of the public based on race or ethnicity or gender? All kinds of questions that reporters and members of the public were trying to figure out. And a common response whenever people asked for records about this or even asked questions about it was for the government to say, oh, Hipaa, we can't tell you anything. And that's not exactly true. So we are going to go through step by step and give you a high level overview of when Hipaa and the privacy rule apply and when they do not. So the first question in the flowchart that we ask ourselves is the entity who has the information that you want a covered entity? Covered entity is a term of art, and it has a pretty precise definition. It includes health plans, so health plans, dental, vision, prescription drug, insurers, HMO, Medicare, Medicaid, supplemental insurers. It includes healthcare providers, so physicians, dentists, hospitals, those types of entities. It also includes what are called healthcare clearinghouses, which are basically billing services or community health management information services. So those are the entities to which HIPAA and the privacy rule apply as an initial matter. If it is not one of those entities or what are called business associates, people that work with them, the privacy rule does not bar the disclosure of information. So, for example, if you're talking or trying to get information out of the governor's office of your state, and the governor's office is like, oh, HIPAA. Chances are the governor's office is not a health plan or a healthcare provider. And so for them to say, oh, HIPAA applies, that is immediately going to raise some questions. That puts us in non-HIPAA land. But assuming that the entity in question is a covered entity, the second question we ask is the information in question protected health information, PHI? The privacy rule is primarily focused on the protection of PHI. What is PHI? It has 3 requirements. It has to be created or received by a covered entity. Number 2, it has to identify an individual, or there's a reasonable basis to believe that it can be used to identify an individual. And number 3, it has to relate to the past, present, or future physical or mental health or condition of an individual, or the provision of healthcare or payments around the provision of healthcare. So again, first question we ask is this a covered entity? The second question we ask is this protected health information? Again, if the answer to either of those questions is no, then HIPAA and the privacy rule do not apply. It's just out of HIPAA land. You're in kind of normal territory. I wanted to note really quickly something about protected health information, because it's possible for entities, government entities and non-government entities, to turn protected health information into de-identified information. And once it's de-identified, then it is no longer protected. There are a couple ways that can happen. You can basically first strip out information and get an expert to certify that the information cannot be used to identify an individual, or at least that it would be very difficult for someone to identify an individual. The second way is through what's called the safe harbor method. If you remove 18 types of characteristics, so for example, names, certain types of geographic information, certain types of contact information, biometric identifiers, if you remove certain types of information from the data, then it is presumed to be de-identified and can be freely shared. So that was early on in the pandemic. That's where a lot of the fight was about whether the information about COVID cases was sufficiently de-identified or not. So you had the press and the public and government entities, fighting about, can we give it down to the county level? Can we give zip code level information? Can we give information about a particular long-term care facility? All of those types of things, we're essentially trying to figure out, is this de-identified enough under one of the privacy rules de-identification methods. So after we consider the first 2 questions, again, is it a covered entity? Is it protected health information? The third question we ask is there an exception that might apply? So even if we're talking about a covered entity, say like a hospital, and even if we're talking about protected health information, so information about the treatment of an individual, there are numerous exceptions in HIPAA that still allow covered entities to disclose that information if certain circumstances are met. And my favorite exception is what's called the required by law exception. And that says that a covered entity can disclose protected health information if it is required by state law. And that includes state public records laws. So I have created a custom URL for all of you who run into this problem that directs you to HHS's own website where they talk about this. The URL is tiny.cc/FOIA HIPAA. And this is your get out of jail free card, because you can send this right to the official. And what it says is, quote, where a state public records law mandates that a covered entity disclose protected health information, the covered entity is permitted by the privacy rule to make the disclosure. This is something that I think is really, really helpful for reporters, journalists, civil society groups, members of the public, anyone who is trying to get information through a state public records law, but is running into difficulties doing so. I think a lot of public officials and a lot of healthcare providers don't always know about the exceptions, or even if they do know that the exceptions exist, they don't understand the full scope of them because they were probably giving a trainings at some point somewhere that says, you know, just HIPAA, don't disclose anything, it's all private, don't do anything. And so their kind of impulse is just to reflexively state HIPAA in response to questions, but it's not always the case. So we've gone through most of the flowchart now, right? So we've considered, is the entity in question a covered entity? If they are not, then HIPAA and the privacy rule don't apply. If they are a covered entity, we ask, is the information in question protected health information? If it's not, HIPAA privacy rule don't apply. But if it is protected health information, again, the final step is to ask, is there an exception to the HIPAA and privacy rule provisions that would nonetheless allow the covered entity to disclose the information? For public records requests, there's an additional step that you have to think about at the end. And that is there another state law or federal law that might apply to the records at issue? And so when you're thinking about this, it's probably going to be state law in the context of COVID or other health conditions. So for example, there's a provision in Maine that says that any person who receives information under a particular chapter of the Maine code shall treat as confidential the names of individuals having or suspected of having a notifiable disease or condition. In Vermont, there's a prohibition against disclosure of information and reports about persons who have venereal diseases. So there are state prohibitions that may or may not affect what you're talking about, depending upon the jurisdiction that you're in. Again, that's why it's important for you to think about, is there a requirement in the public records law that the information be disclosed? Or is there some other provision, in the public records law or in your state public records, or I'm sorry, in your state law more generally that might apply to the information? Because if state law bars the dissemination of the information, then HIPAA and the privacy rule are also going to kick in and bar the disclosure of it. So that is the general process by which you go through figuring out, is it true that this hospital can't produce this stuff? Is it true that the state or local entity can't produce this information? There's some common questions that I've run into in dealing with this that I thought I would also address for you all. And then we're going to have a few minutes for Q&A. So the first question is, what about if the person is dead, right? What if you're asking for information or trying to get records about someone who is dead? Does HIPAA still apply? The answer is HIPAA still applies for 50 years after the date of death of the individual. After 50 years, it's all fair game. But in between the time of death and 50 years thereafter, HIPAA continues to apply. Another common question is, can you disclose your own protected health information? Yes, you absolutely can. So for example, I can tell you all that I am vaccinated and that I got the Pfizer vaccine, et cetera. There's no prohibition on that. What about, can I authorize my healthcare provider, or can anyone authorize their healthcare provider to disclose protected health information to a third party? Yes, you absolutely can. With signed authorization, a covered entity can disclose, in fact, the entirety of a patient's medical record to a third party. So as long as you have signed authorization, that's totally fine. Another common question about HIPAA is, and you actually see this in movies and TV a lot, someone runs into the ER and they say, hey, where's my sister? Where's my husband? How are they doing? There's an exception to HIPAA called the facility directory exception that allows hospitals, healthcare facilities, et cetera, to provide basic information when they are asked about a patient by name. So that includes the location in the facility, their condition in very general terms. So like, are they critical? Are they stable? Are they deceased? Have they been released? That kind of very high level information, as well as their religious affiliation. So if you go into a hospital and you ask for a patient by name, that type of very general information can be provided. If you're interested in reading further about HIPAA or understanding all of the nuances, I encourage you to check out the Reporters Committee's guide on this. Again, that's at rcfp.org/COVID-19. I also wrote a journal article on this with one of my colleagues. You can check that out. It's in the Journal of National Security, Law, and Policy. It goes really in depth into how the news media interacted with public officials and government entities during the pandemic, and the lengths that they went to try to get information about the pandemic. One of the other interesting exceptions to HIPAA that my colleague and I argued about in this article was a little known exception that says when it's possible for a covered entity to lessen an immediate health threat to the community, they can disclose protected health information to entities or persons that might be able to lessen that threat. And we argued that especially early on in COVID, where there was not a lot understood about how it was affecting, especially communities of color, that healthcare facilities should have done more to provide information to the press that would have allowed them to alert those communities to take additional measures. So in Louisiana, for example, the press was writing stories about how COVID was disproportionately affecting Black Louisianans much earlier than the state government was admitting. And had they been provided with more information earlier on, it's possible that they could have done more to alert that community. So that's another exception to HIPAA, but there's a whole slew of them. If you want to go check out the links in the RCFP guide. So with that, I will turn to some of the questions and answers. So we have one question. It says, can you give an example of when this exception would come into play? Oh, I apologize. I'm not sure which exception you were talking about. Was it the required by law exception or one of the other ones? If you can put that in the chat, I can try to answer it, but I'll go on to the second question, which was, so autopsy reports have to be 50 years old before you can legally obtain them. So autopsy reports are going to vary widely by state. Usually HIPAA is not a factor as much as the state public records law. If you want information about this, the Reporters Committee has what we call our open government guide. And we have a specific section on autopsy records and coroner's reports. You can see what the law is in all 50 states and DC. Some states it's open and available. Some states it is not available. It really depends. It's the type of thing that you would think there might be more uniformity on within the United States, but there just isn't. So the first question was when the exception, when the required by law exception comes into place. So it's primarily in the context of public records laws. There are also some instances where state or local entities or healthcare providers have reporting requirements, including, for in certain types of infectious diseases, where they need to notify state officials higher up that there's something brewing, essentially. There's some kind of disease that is being transmitted and might affect the community. And so that's another example of when the required by law exception might apply. But I think for the public's purposes, the public records aspect of it is particularly important, because that's how we would come across it. Question, can an employer force employees to prove they were vaccinated? That's really going to depend on state and other federal law. That's kind of an employment law question rather than a HIPAA question. So I'm unfortunately not qualified to opine on that.
Adam, it looks like we have maybe one more question here before we wrap up. Janine Wiseman's asking, what can I reasonably expect a hospital spokesperson to reveal about a patient admitted after some kind of accident that I reported about?
Yeah, so spokespeople are probably going to be pretty circumscribed in terms of what they are talking about. Again, under the directory exception, they can provide basic information, where are they, what is their status, that type of thing. Once you're in PR land, those kind of considerations may take precedence over what is the strict legal question of what they can or cannot provide.
Adam, if you wouldn't mind, can you provide your contact information for those that might have some follow-up questions or would like to reach out to you and your colleagues?
Absolutely. So you can follow us at RCFP on Twitter. You can follow me at _Marshall_plan. You can contact our hotline if you're a journalist and you have questions about HIPAA or any of this. That's rcfp.org/hotline. So yeah, please feel free to get in touch if you have questions or additional thoughts.
Adam, thank you. And thanks to you all for joining us today. Take care.
Thanks, everyone.